But the next is Reyes-Corado v. Garland, published by the Ninth as well. And this is a change country condition motion to reopen. So the other type, the kind where you can apply for asylum. And, love this case because it's a big win from my literal neighbors, Ginger Jacobs and David Schlesinger, and their law firm. And, I know they're great attorneys and it's a hard fought win. And I spoke with Ginger and David, and they've represented Mr. Reyes-Corado forever. So those are always the best kind of wins. But essentially, Mr. Reyes-Corado had this family dispute in Guatemala, and without getting into it, it involves the Guatemalan Civil War, his father and his uncle on opposite sides of that, and killing each other, cousins killing each other, threatening each other. It's terrible stuff.
A real civil war, yeah. That's a real
civil
war.
I mean, interpersonal civil war. Yeah. But that was his claim in immigration court years ago, and it was denied. But he said things got worse, and so he filed a motion to reopen. Things got worse on that claim. The cousins still want to get him. They've been killing the family livestock. They've been threatening his grandma, those kind of things.
There's that old case from the South, I think Mark Twain wrote about too. These two families that were just there's two last names that they're famous, the Things and the Things.
Hatfield and the McCoys?
Yeah. It's the Guatemalan version of that.
I guess, but I mean, these are actual family members. I mean, they're two separate families, but they're they're cousins. But that's probably the same. Probably the case with Mark Twain too. Everybody was a cousin back then. But I mean, there's great quotes in this one. For example, starting off with saying that change country condition motions to reopen serve as a quote important safety valve in the asylum process. I mean, that's a big deal, especially when you got decisions like Matter of Coelho saying they're disfavored. Well, actually, no, they're an important safety valve. At least when you've got the claim, not when you're abusing it, of course. Before getting to the substance, this is also the Ninth Circuit reaffirming what it said a couple of months ago, but actually being much more clear, saying that when you're filing, and don't quote me on it, read the case because this is a big deal. And to be honest with you, I'd probably still include it. But they're saying when you're applying, when you've already applied for asylum and now you're applying for asylum based on changed country conditions with essentially the same claim, but updated conditions, you don't have to include a new I-589 application with your asylum application because it's already in the record. For all other forms of relief for a motion to reopen, for all other motions to reopen where a form of relief is the basis, you got to include that application. Ninth Circuit says that doesn't make sense with the change country condition motion to reopen for asylum when you've already applied for asylum. So, maybe still include it because why have the issue? But there's reasons not to, and I haven't included it before. And the case law in the Ninth Circuit, and I believe the Second, but do your research, indicates that you don't have to include an I-589 or even your old I-589 with your motion to reopen. So there's that procedural thing, because that's a great way that the BIA will always ding a motion to reopen. Can't do that ding in the Ninth anymore. But, here then on the substance, the Ninth is saying, materially change country conditions, fine. But it doesn't require a, quote, dramatic change, end quote, especially when, again, quote, conditions were already severe, end quote. All it requires is that the new circumstances, and this is their quote, I'm just paraphrasing a bit, take the fear across the threshold from, not well-founded to founded. And you can be really close, right? I mean, whatever, let's call it percentage. They say asylum is a 10% chance of persecution to the extent that you can equate such things. I mean, maybe you were at 9% because there was really bad harm, but the immigration judge just didn't see it was there. Well, then a decision like Reyes-Corado would indicate that you don't need some crazy change to get from 9 to 10%. Maybe it's less when it's already severe. And by the way, an interfamily dispute can cut it. I mean, all that was happening really in Reyes-Corado was the same stuff that was happening. It just kept happening and happening and happening. It got a little worse, but it had already been pretty bad. And I said that's sufficient. So Reyes-Corado, monster case for change country condition motions to reopen in the Ninth Circuit, published the same week. I want to say it was a couple days after Fonseca on all other motions to reopen. So big week there in the Ninth, big month in August for motions to reopen.
1-2 punch. There you go.
1-2 punch. I mean, you got to think it's intentional.
Yeah, probably. Yeah, I imagine when it comes to courts, like a lot of things are, it's almost like a wrestling match planned out ahead of time. How are we going to put it out? And nothing goes to chance because there's too many brains thinking about this stuff and some coordination happens.
I'd love to know the politicking that goes on behind the bench in the appellate courts and the Supreme Court about what they publish, how they publish it, when they say it. Because I mean, it's politicking. They say, that Justice Sandra Day O'Connor was pretty successful at that stuff, as was Chief Justice Earl Warren, because they were both politicians before they came on the bench and, building consensus. We like to think that law isn't like that, but of course it is. Of course, Justice Kagan is pulling her punches sometimes and even signing on to a majority decision because she's, maybe she's gotten some concession from Justices Roberts and Kavanaugh for something else. I mean, there's no way that's not happening. There's no way.
I think it was in the movie. I saw a movie, Earl Warren, I think, Board of Education stuff. He was negotiating all of them to do it, all that kind of stuff. So, if it wasn't boring for regular people, it would make a great reality show or some sort of TV show, the judges and show.
We can make it interesting. Add in some sex appeal to the bench, I suppose. Yeah. They have an affair, but I don't even think you have to make up the affairs either. I mean, you could probably. My point is you could probably do.
It's there. Yeah, the contents will write itself.